Welcome back to our discussion segment on Good Morning Anambra. This morning, we are going to be delving into a controversial issue that often is being misunderstood, aspect of the criminal justice system, plea bargain. That's what we'll be talking about this morning. Is a practice that many argue is actually essential for maintaining efficiency and fairness if overloaded courtrooms are okay, while others believe it's a loophole that allows the wealthy to buy their way out of accountability. Today we will explore whether plea bargaining is truly a tool for justice or is just becoming a privilege reserved for the wealthy in our society. So join us this morning as we examine its impact on our legal system, its ethical implications, and whether it's time for reform. Okay, so we have in our studio this morning Simon Nwafo Ezofoma Esquire. He is a human rights defender and also a public affairs analyst. Glad to have you on the show this morning.
Good morning, my host. Good morning, Anambra, and all our viewers.
All right, like we said, our topic this morning is plea bargaining, a tool for justice or a loophole for the rich? That's a question that is begging for answer, and that's why we are here today to talk about it. And of course, we have a legal luminary with us in the building this morning that will help us understand what plea bargaining is all about and how it functions also, and how has a plea bargaining also involved in the legal system?
Yes, excuse me. Plea bargain is defined in different ways. Even the Black Law Dictionary defines it. But the definition I may put to it is similar to that defined in the Black Law Dictionary, which says that a plea bargain is a negotiated agreement between the prosecutor or prosecution and a criminal defendant, whereby the criminal defendant is expected to plead guilty to lesser charges in concession to multiple charges or heavier charges. So that is summarily what plea bargain is all about. As we go on, we shall explore other aspects of it and the other loopholes, because you have even it is already developed. This is contained in Administration of Criminal Justice Act, Section 270 of Administration of Criminal Justice Act. You will see it talks about plea bargain, and as we go on, we will see that you have even count bargain, you have a charge bargain, you have sentence bargain, and so on and so forth. So, as we continue, we shall see how it has helped or functioned in Nigeria, because we know that it's a very good development, it's a very good principle. Or this thing. But it depends on how it is operated in different climes.
Okay, so you talked about the charge bargaining, the sentence bargaining. So it means that we have different types of plea bargaining.
Yes, it is contained, all of them are contained in the same plea bargain. The only thing is that, you see, sentence bargain means that there can be a negotiated agreement that you will be sentenced to this, and then instead of giving you heavier sentence or this and that. The same thing, charge bargain, just as I said, you have multiple charges. So there could be a negotiated agreement that you will be given a lesser charge instead of a heavier, and a concession for a heavier charge. Then the criminal defendant will plead guilty to that lesser charge in concession the heavier charge that would have been preferred against him.
Okay, so let's talk how it has evolved in the legal system in Nigeria and how it has also helped in expediting judicial process.
Yes, just as I said, it's a very good principle or this thing, because the draftsman the proponents of this principle have it in mind that it is a situation where you have win-win situation. Because let me take, for instance, like in a system like Nigeria or so many other places, instead of somebody going to waste in the, for instance, I heard yesterday that one woman was testifying, giving testimony that the husband that was illegally accused or charged for an offense, and he stayed in the custody, in the prison custody, without a fair trial for 3 years, only to be tried and found and discharged and acquitted. That is, he had no offense. But he has wasted 3 years. So there are sometimes somebody may steal small things. The other day we were with the chief judge of Anambra State, and so many in the prison visit. We were in the Oka prisons where the chief judge made a prison visit. You see some people who will be brought to the to court, who will be accused by the, who will be brought into police custody, and they abandoned there. They'll be wasting. So even when somebody is accused of stealing a phone or a small thing, instead of the person to, it is better that the person is given some punishment or lesser punishment, and then the person will go and they work and they pay for that thing. That is all instead of wasting. And when he wasted, when he has waited in the detention for 3 years, that thing that he stole has not been repaired. Instead, there could be a negotiation. Okay, go and make money or do this work and then pay for that thing. Then the person who is deprived of that thing, it will benefit. And that person will continue his or her life instead of wasting there. So when the prison is discongested, and then the two parties are settled, that is the wisdom there. But you know, nothing works as it ought to be in Nigeria. I will put it that way. Because in our present situation now, the powers that be, the politicians have capitalized on it. So somebody can, and the corruption that is, eating deep in our system. Somebody can steal billions, trillions of dollars and naira, and then go and put it, and they'll just go and settle with the powers that be. Okay, bring 100. Because sometimes even you see that a thief will thief, another thief will thief upon it. Some people used to say that all the money that EFCC is recovering, they are not accounting for it. So they are like, okay, look at the drama that is surrounding Yaya Bello's episode. So that is not the intent of a plea bargain. That is not the intention. That is not what it is intended to solve. The intent is that instead of wasting the state resources, congesting the prison, and then the human power placing in the person might have repented or is sorry for what he has done. Then he will make use of his human power, and then pay for that in a way that it will not be it will be justice to both sides. So that is the intention.
Okay, thank you so much for that. But we are still talking about plea bargaining. What ways can this plea bargaining ensure that victims' rights are upheld while still achieving a fair resolution in criminal cases? Yes,
that's what I said before. And you know, one thing in Nigeria is the other day we were in court, and you see so many people who will be charged. I was discussing with somebody in overseas here. I told him that, do you know that in our present Nigeria now, if you want to be doing things right, you will be seen as an odd man. People will be looking at you as if you are wearing, back of the shirt. So there will be a question whether you are in the system or is anything wrong with you. So I had a very good this morning about even what is going between Afe Babarola and so somebody made, an analyst said something, quoted what an American said to the government. He said, in a situation, in any place, in any environment, where reporting crime is taken as committing crime, then they are ruled by criminals. That thing, that I read meaning. Whenever reporting crime is taken as committing crime, then the society, that group, that is ruled by criminals. And because it is only where criminals rule that when you report crime, then you will be treated as a criminal. It will be taken as you are the one committing crime, because nobody wants the truth to surface. So what am I saying? Even sometimes victims of crime, like rape, like others, they will be timid or this thing not to come out. The other day we were in court. The judge, the lawyer, the prosecuting counsel was following a criminal rape issue. And then the other lawyer was just giving sign. I was with just by neighbor. Then they come and whisper something to the lady. The lady just ignored her. So he said, come now. Go and ask your seniors. The lawyer doesn't refuse her. What is he trying to say? To cut short, to use short cut corner way, to end the criminal, the rapist, that they have spoken to the girl. The lady said, I have told you what. Even they brought it to the notice of the judge. The judge told him that I don't know what they are talking. That a crime is not, nobody is a complainant in a criminal. It's the state that is. In a crime in a high court, it is the complainant. So even the person who brought the thing to the police or anything is just a nominal complainant. So you don't have the right to just end it like that, because it is what are we trying to achieve? Justice to the victim, justice to the culprit, and then justice to the society, the state. That is the this thing. Justice to the victim, justice to the culprit. So you pay for you suffer for what you have done. That is the law. For whenever there is a wrong, there is a remedy. Justice to society to serve as a deterrent. The people will say, okay, this person who did this suffer this. Therefore, it will deter people from going into it. But in a society where if you have power, if you have connection, then you can even throw somebody, you can throw somebody into gutters, kill the person there, then sleep. Or the person will be even timid, or the person will go back. Nigeria some people can, because of hunger, somebody may be raped. The lady that was raped, she was there, hearing that she has agreed to end the matter. This is not that she's ashamed to show.
But she agreed to settle out of court.
She was hearing that the lawyer said that they have agreed with her that
but she was not aware of that before coming to the court.
No, what I'm saying is the lawyer just called her outside.
Okay.
Then trying to convince the state council.
Oh, okay.
So the lady has gone at the back, and then she came to court. Not that she's not interested. Maybe they are giving her 2,000 or 3,000. Because if they have a peaceful settlement, she wouldn't have come to court. Just outside the court today, she called this and that, give her 2,000 or 5,000. Then she will abandon. Her watch was taken. She was raped. This and that. And then if you look at her, then you know that. So that is the problem.
So factors like that can actually make someone, agree to end the case or take away the case out of court just because maybe the person is hungry.
It's hungry. What could have brought about that? If you look at her, you see that a very responsible person couldn't have done that. It's not decent. You came to court because you were raped. The materials were stolen. And then, just outside there, the lawyer was doing like this. He went out and told me that the matter was to frustrate the matter. Then you went and agree with leaving your counsel. If there is any negotiation, your counsel must be brought in. The state council, then the woman was saying, the state council was saying that he told him, go to the DPP. If you want the matter, go to the appropriate quarters, then discuss with them, then discuss with the victim. Then the matter will be settled amicably, and not going it by corner way.
So in other words, it means that, someone like, because we have been talking about the rich people, what about when a poor person actually commits an offense? It means that we plead by the person can go for a lesser sentence.
That's what the point, the aim that is supposed to be achieved is not to, sabotage justice, but to achieve justice in a very mitigated way. In a mitigated way. So the whole aim of plea bargain is that punishment will be mitigated. But there must be this thing for any wrong that is done. There must be a remedy. For instance, now, if somebody steals sometimes when people report things, they are not interested for the person to go and die in the prison. I'm interested, if you steal my car, I'm interested in receiving, in having my car back. So if there could be an agreement, maybe you suffer for, the matter is tried, or we negotiate that you will suffer for 3 months, you go and work, you'll be paying this. And then you plead guilty. Then you'll be paying this. Then give me my car. You have suffered, even being arrested and detained. You have paid for what you stole or you damaged. And then the victim is settled. Then I don't think you will, even at the time you will take, instead of you use it to pay for another thing. It will not encourage you to go and do it again. So that is for the poor. But what you are taking for the rich is you will still state money, and then you negotiate with the EFCC. It's a common thing now. Even the customs and this and that, they will tell you they are bribed. They offered to $11,000, this $1,000. So you negotiate with them, then you go and eat state money, and then it's not the state. The head of that this thing agency will just take his own. Just take your own, I take my own. Then the matter will die. That is it.
Okay, well, under ethical considerations, how do prosecutors and defense attorneys, how do they balance justice and the interests of their clients when it comes to these plea negotiations? That
is the point, because a lawyer is trained. A lawyer knows better than the litigant. That is why you employ a lawyer to your service. In the real sense, just as the instant case I was pointing at, in the real sense, for any negotiation, the litigant will be, the client will be the determinant of what step will be taken. But in consultation with his or her lawyer, a lawyer will not, whatever a lawyer is going to offer will be the decision, the opinion, the final thing will be what the client wants. But a client cannot go out. Another lawyer in the other side cannot influence a client and oust his lawyer or her lawyer. So that is the point. When the two parties come together, the prosecution and the defense, when they come together, the lawyers will agree and know terms. And then those terms will be registered. And that is why sometimes you see cases surfacing, or you see something. People may think that this matter, because you can be duped, because you are not a professional in that line. You can be deceived. And that thing can come up tomorrow. For instance, we used to say, even in a nolli prosecute, an attorney general, so in our system, an attorney general can come and they exercise the power of nolli prosecute. That is, I don't want this matter to go on again.
Okay.
Now, but the law is that defendant or that suspect is discharged but not acquitted. So which means he can be going out there now and is arrested again. So that is the point. So in cases like that, the people who are not trained in that line, may even think you can. I was discussing with a colleague the other day, just 2 days ago. He was saying a matter they have with Zone 13 or so. So it's not a serious matter. But because they want to know no man, this and that, they went to the AG to stop the matter. Then he connected his own person again and went to the AG to explain. After explaining, the AG ordered for the file to be brought back, to be retired. So that is the point. So it's when to the two lawyers who are professional, and if they are honest in their profession, they will give the expert advice. They will give they explore the judicial relationship. They will advise their clients on the best way out. And if they agree, if the clients, with the consent of the clients, then the matter will be resolved amicably. Every party will benefit. That is win-win situation.
Okay. All right. We'll still continue with our discussion this morning. Remember that we are looking at plea bargain, whether it's now a tool for the rich or still a justice, a tool used for justice. And we have interviewed some parliamentarians outside the studio this morning on the streets. So we want to get what they said about plea bargaining as a tool or loophole in judicial, or rather in legal system. Let's hear them.
It's normal because it's been practiced even in the Western world. If you have to commit a jail term, or if you have to commit an offense, and your jail term should be like maybe 10, 20 years in jail, and maybe you now plead for mercy after pleading guilty, and you now say, okay, the judge might decide to maybe you pay a certain amount of fine, depending as is stipulated by the law or by the judge. When you pay that fine, you have the right to be set free. So I don't think it's maybe something fishy or something illegal. It's normal. Sometimes you have to get your resources right to save you when it comes to that kind of issue. Whenever you have the money to bail yourself out, that one is legal. When you're being passed to the judge decides how much you pay. Even in most cases, when they ask you to pay maybe 500 million, and you don't have the money, you can plead for maybe for reduction. So, but that one is normal. If you have the money for you to serve that your jail term through funds, you can pay the money and be free.
That's the situation we find ourselves in Nigeria. The corruption has been legalized in this country.
Your opinion on what? Your opinion on plea bargaining.
My opinion on plea bargaining. Do you understand? So corruption has been legalized in this country, whereby a rich man commits an offense because of his position in the society. He will now either make some bribe in order to evade justice. You understand? So, but it's like the law has been made for the poor. Do you understand? And when a rich man commits offense, he go free. But a poor man commits offense, he will be paid dearly for it. So that is it. So that's much I can say.
It's not good for our judicial system. Why? Because as I earlier said, the rich can take advantage of this to oppress the poor.
Simon, you've seen what the people, our respondents, what they have to say. Everyone is saying that the rich actually is using it to, as it's a loophole on the side of the wealthy in our country today. And you also, re-echoed that particular point.
Yes.
But that's not the aim why this particular, the plea bargaining we're talking about, why it came into existence. There was a reason, especially when we have a lot of cases in courtrooms that we need to decongest. But right now, because someone also said that corruption has been legalized in our country, probably because of that, things are going haywire. But now the question is, can this plea bargain system, can it be reformed to ensure fairness and also to serve out the reason why it was put in place initially?
Definitely. The point is, do you know that even people have formed that mindset or mentality that even if you are doing things right in this ABS now or in any place, people have formed the mentality that that to show that no Nigerian is good. So what I'm saying is, it is that intention is ought to be achieved, and we can reform it. That is why the Administration of Criminal Justice Act and the Administration of Criminal Justice laws of different states were made in the first place. And that is why this plea bargaining is incorporated in it. Mm-hmm. Just as I said, Section 270 of the Administration of Criminal Justice Act. And if you read through that, you see that the intention, just as one of the commentators mentioned, the whole aim, even whatever the negotiated agreement or compromise between the parties, it is for the judge. It is only when the judge grants that. It is for the judge. So when that is there, but the court is what you pray the court, that the court will do for you. So that is vital. It is, the court must assent to that. The court must agree to that for it to be entertained. But what I'm saying is it could be reformed. Both the society, the judicial officers, and every citizen, we will all make up our mind to better the society and to make justice what it ought to be. Justice and the equity go hand in hand.
Still talking about the reformation of this particular system, can we actually limit the scope of plea bargaining? Probably particularly in cases involving serious crimes, when we talk about murder, sexual assault, and of course embezzlement of funds. That
by right, something like murder, and so on and so forth, armed robbery. Okay. You don't. That ought not to be among. The only thing is, as I said, plea bargain is not meant to negate justice system. There are some serious crimes, but something like we know the problem in our society is embezzlement. Yeah. Now, there are certain things the law must take its course. Even that embezzlement, the way it ought to be is, you can tell the person, just as I said, to plead guilty to a lesser charge. Okay. Then you recover those the money embezzled. Not somebody will take billions and billions of dollars. Then you plea bargain and take our money. And the sins will be forgiven. And the sins will be forgiven. No. But instead of being in jail for 30 years, okay. If you plea bargain and the person is agreed to recover, to bring back the money, then suffer for 3 months instead of 30 years. It's better. It doesn't. At least he has saved his life. The money is recovered and put in the right place, not recovered by the police. That when I mean police in quotes, because people used to say, "Who polices the police?" And not to recover and be taken by the person who recovered, but recovered back to the society. And then you bring the money you have stolen, serve 3 months or 6 months, and then nothing. It's win-win situation.
Don't you think that with this that you have just explained, with this plea bargain system, especially for those in top government positions, when it comes to embezzling of funds, that once they see that, okay, if I can embezzle a certain amount of money, and at the end of the day, I'm being taken to the court, and I'll plea, I will bargain, at the end of the day, they might give me a lesser sentence, and then I pay in some cash, and then I'm good to go. So why don't I embezzle the funds I need to embezzle while I'm in power, and then deal with the consequences aftermath?
The problem is our system. If you look at even the president, Trump was facing a criminal charge before he was elected. Mm-hmm. The son of the incumbent president was sentenced. So look at what I'm saying. If we have a good system, which will follow the matter, diligently and conscientiously, let me tell you, you will not gain any. For instance, by the time, even before the time you will be detained, if actually they will recover all the money you have embezzled, then you spend the 6 months in prison, and then all the money is, tell me what is your gain for you to go out, because that is the point. And then look, and the point, another thing there is, your name may, unless you are given pardon or amnesty, but when the court has ruled that you are sentenced for 6 months imprisonment, even one day, you are an ex-convict, which may even deprive you of holding political position. Why did Biden pardon his? Because once you have that tag, it can deprive you from holding some public offices in life, unless that is extinguished.
Okay, now this next question, I'm asking you just like an average Nigerian, not as a lawyer. How the public actually perceive plea bargain? Because that's the problem we are having. Some people are saying is that it's actually the tool the rich people are using to oppress the poor. Let's forget about those in top government offices. Let's talk about the sexual assault, and then people that can just decide to take someone's property away from them just because they are rich and all that. So the public, how they view this?
That's why I've already said that the mindset and mentality of every Nigerian is that nothing works in Nigeria. And I don't blame anybody. Because look at the things you are seeing. The administration of criminal justice system, the electoral system, and so on and so forth. You see things being manipulated before you. Then how do you convince a layman? I think I was saying somewhere that somebody was giving a lecture in somewhere, and he said that let Justice Yoput of the Supreme Court said that justice is built on confidence. And that confidence is destroyed when a reasonable man walks out of the court with the impression that the court is biased. Justice is built. Why people come to court is that they believe they will get justice. That's why they say it is the hope of the common man. Then that when a reasonable man, not every man, the law is always interested in the opinion of a reasonable man. Then when a reasonable man walks out of the court, having seen what is done or what is happening, and with the impression that the court is biased, do you think that he will come tomorrow, he will be encouraged to go and pursue his matter tomorrow in court? Because he said, which court? Is it not they will do it in that mago way? So that is the point. So what I'm saying is, I don't blame people for that, because seeing our electoral system, seeing what they see, look at now, even this morning, that somebody, the other day, a non-lawyer is put in handcuff and brought to the court. I was discussing with some senior lawyers, and they said, somebody was saying, that even as a defendant, our law system is, an accused person is presumed innocent until proven guilty. So that is why if you used to go to court, you see that whenever defendants, suspects are brought to, they even from prison custody, they will be in handcuffs. But immediately they enter the dock, you remove their handcuff. Because there and then they are presumed to be innocent. The law has not got proven. So they are just like every other citizen. But this one is a no. Then the judge saw it and did not intervene. So how do you convince a layman out there that because he said he defamed somebody, which is not a criminal offense in the state? Defamation is not a criminal offense. That is the system. And even this morning, the another one is saying that he said he's going to pursue to make sure that he doesn't practice law again in Nigeria. You see, when the justice system is mortgaged, is bought over by the power that be, then how do you expect a reasonable man to trust in that justice system? So I don't blame anybody.
So in other words, because we are about running off this particular segment, so in other words, our topic is it a tool for justice or a loophole for the rich?
Yes.
Give me an answer to that question.
Yes. generally, it is supposed to be a tool for justice, as I said, to ensure win-win situation. But it depends on each peculiar circumstance. In our own environment, they have turned it to be a loophole. And you know, we are just embracing it. It's just coming into the system. Okay. It is not even every place. People are just knowing it. It has been in some systems, some areas, we are just coming into it. So as we said, if we can modify it to suit the purpose for which it is made, it is supposed to be a tool for justice. But as it is present practiced, it is a loophole for the rich.
Okay, thank you for that honest answer coming from you. But instead, we can do something to reform that particular system, because the main reason why it's put in place initially is for it to be a tool for justice. Well, on that note, we want to say a very big thank you to you, Simon Nwafo Ezo, former Esquire, for being a guest on this particular topic this morning. We really appreciate your presence. Thank you very much for having me. And thank you, all our viewers. Let us all join hands to make this society a better one. All right, so thank you so much for joining us, our viewers. That's it on the show this morning. My name is Chidimma Oranwa. I want to tell you to enjoy and have a beautiful weekend. See you again next week. Bye for now.